We're here today with Professor Uglow. He is Professor of Law at Kent University, and he's advised the EU on electronic evidence, its admissibility and the weight which may be given to it. Professor Uglow, you have researched the admissibility and weight of handwritten signatures, handwritten electronic signatures. Which legislation did you look at?
Yes, I've been able to look at, obviously, the common law on this area and the Electronic Communications Act of 2000, as well as the European Directive of 1999, and in addition, of course, the various research literature surrounding this topic.
I understand there are two ways in which signatures could be admissible in court. What are these?
Yes, I think one is as an electronic signature, as defined under the 1999 EU directive. And the second way would be simply common law, where it would be part of documentary evidence.
Okay, can you explain in the first instance then how the signatures would be interpreted?
Yes, if it was a electronic signature under the 1999 directive, then it has to meet certain requirements under that directive. But if it satisfies those requirements, then quite clearly will form not only admissible evidence, but highly probative evidence of the authenticity of the signature. I would suggest that, going further than that, it would be treated under the 1999 legislation as an advanced electronic signature. And I think in that case, not only would it be admissible as evidence, if the requirements were shown to have been met, then I think the burden of disproof would fall on the party seeking to challenge the authenticity of the signature.
And what about if the signature was interpreted as documentary evidence?
Yes, common law, basically, one has to always to prove the authenticity of any evidence that you put before the court. I think in this particular case, if one put an electronic signature before the court, then again, as long as one proves its provenance, where it's come from, you prove the reliability of the methods which have been used, how, when and where it was taken, then again I think the electronic signature is not only admissible but would have significant weight. It would be very difficult to disprove.
Okay, so really then, electronic handwritten signatures can be relied upon in court if the signature data is sufficiently accurate and can be proved to be so?
Yes, as long as, where it is challenged that is, then as long as it is shown to be reliable, then it is certainly admissible in court.
So, continuing that then, if the accuracy of the data provided can be challenged, the accuracy around the signature data, could the document be disregarded?
Yes, I think there is, when you say disregarded, I think it's a question of whether it is admitted as evidence, and then if it is admitted, whether it has what weight is given to it. But certainly in the sense that if the technology which is shown to have produced the electronic signature is unreliable in any particular way, or, for example, there is a high error rate, then there is a great danger that the court would refuse to admit it into evidence, or, if it was admitted, treat it as nugatory probative weight.
So I take it then that if this particular technology, the particular signature capture device, was challenged and the evidence was found to be unreliable, that each subsequent time that similar evidence was presented from a similar device, similar problems would occur?
Yes, I think once a particular device has been shown to be flawed in some way, there is great danger in future in relying on that. One can think of the analogy of a new breathalyzer, which is brought before the court where defence counsel successfully challenge the technology behind the breathalyzer. The case is thrown out. Then after that, I think it would be a very brave prosecutor who ever sought to rely on that again. I think the same would be with these sorts of devices.
Quite, thank you for that. So I suppose then it's also important to have an audit trail to prove the correct function and the reliability of the device which has captured the evidence.
I think that's absolutely right. I think in a court of law, any evidence must be shown to have a proper provenance, particularly, of course, documentary evidence. And proving how and when and where a particular paper document, for example, was produced can be fraught. Where you have an electronic device which has built-in safeguards which records for itself when and where and how the signature was made, then of course the problem of provenance becomes much less. And being able to demonstrate a good audit trail, I think, is central to having the evidence admitted in court.
Thank you. Dr. Guest, who's working on the ISO committee for signatures, looked at the motion touch Legapad and reported on its capabilities. You've looked at that report. Does the Legapad fulfill all of the requirements for electronic signatures?
Absolutely. I think, as I said earlier, I feel that it would be regarded as an advanced electronic signature within the requirements of the 1999 EU directive.
And because it has the audit trail and there are almost negligible error rates on the Legapad, then it would withstand the sort of challenge that we've discussed today.
Yes, I think it will be a very robust piece of evidence.
Thank you. In your opinion, does the Legapad lead the way in this area?
From what I've seen from Dr. Guest's report and what he says about other similar devices, where there are considerable doubts about the reliability, about how they capture their data, about audit trail, then yes, I would think that the Legapad looks like the leader and looks as if one would be quite confident about relying on using that signature in court.
You've looked at the situation across the EU as well as in Britain. Are the findings the same in the other countries in the EU?
Yes, I think across the EU, I think I would have to accept the Romania and Bulgaria, who, as I have never looked at them, but certainly the more traditional members of the EU, the Legapad signature would certainly be admissible evidence in all courts across the European Union.
Professor Uglow, thank you very much.